Before we begin, permission to set up the will with the demonstrative evidence?
Has opposing counsel seen this?
Yes, Your
And any objection to, oh, you're not going to demonstrate it right now, you're just
No.
setting it up? Okay. You may.
May I proceed?
You may.
Good afternoon.
Good afternoon, Miss.
Please introduce yourself and spell your last name for the record.
Certainly. My name is Francis Reese Warren. Warren spelled W-A-R-R-E-N.
Dr. Warren, what do you do for a living?
Well, currently I'm a professor and also the chair of the Department of Linguistics at Midland State University. I also consult closely with the Midland State Police Academy in lecturing both their cadets and seasoned veterans on how to properly gather testimony during an undercover operation.
You mentioned linguistics. What is that?
Well, linguistics is the study of languages.
And so what is your education in the field of linguistics?
I received my PhD in linguistics from Georgetown University in our nation's great capital. Before that, I experienced undergrad at the University of North Carolina, my home state, and consider myself a devout fan of the Tar Heels as a result.
What experience do you have in the field of linguistics?
Well, I've published 37 peer-reviewed articles that have appeared in both psychology and linguistics journals. On top of that, my textbook, How to Speak to Alleged Criminals, is actually standard reading at many police academies throughout the nation, including Midland State Police Academy.
So, Dr. Warren, what are some of your responsibilities as a linguist?
Well, as a linguist, I consult closely with forensic psychologists in order to determine and examine how what you say, both verbally and non-verbally during your conversation, affects the other participants in that conversation.
Could you please explain to the members of the jury how linguistics relate to undercover work?
Absolutely. When you as an officer of the law are conducting a conversation with a suspect while undercover, you have to take certain precautions in order to avoid inducing criminal activity in someone that might not otherwise be willing to engage in it. You have to structure your conversation carefully, as well as avoid strategies that have been shown to induce criminal activity in unwilling suspects.
Dr. Warren, how exactly are you involved in today's case?
Well, originally I was retained by the defense in order to analyze whether or not the actions of the Midland State Police Department rose to the level of entrapment during their investigation. After I provided my conclusions that the police department acted within reason, I was told I'd no longer be needed. And it was at that point that I was approached by the state and asked to testify on behalf of the state today.
Well, to complete your assessment, did you have sufficient facts and data?
Yes, the defense supplied me with a tape of the March 31st conversation between undercover officer Mickey Keenan, casino owner Avery Bancroft, and Ms. Bancroft's executive assistant, Corey Hyde, who at that time was acting as Officer Keenan's informant. I was also provided with a March 30th email exchange between Officer Keenan and Corey Hyde, as well as both the affidavits of Officer Keenan and Corey Hyde.
What principles and methods did you use to complete your assessment?
Well, I conducted multiple linguistic analyses that passed peer review in order to determine that the conversation on March 31st was structured in line with what linguists believe to be the best practices.
What are the best practices that you use to come to your conclusion?
Well, the first step that you should follow is, in structuring your conversation with the suspect, ask open-ended questions in hopes that the suspect that you're engaging freely incriminates themselves. Now, the second step that you should follow is you should begin to drop subtle hints of criminal activity without expressly stating what it is in hopes that the target latches onto these and further incriminates themselves.
So, Dr. Warren, did you apply these best practices methods to the facts and data that you were supplied with?
Certainly, this is exactly what I lectured the cadets at the academy to. It'd be a little amiss of me if I didn't apply those reliably in my line of work.
So how exactly did you begin your analysis?
Well, I again began with a simple transcript analysis in which I examined the tape of the March 31st conversation and transcribed what I found. Now, during that transcript analysis, I did indeed find that Officer Keenan and his informant Corey Hyde began the conversation by asking clear, open-ended questions such as, what are you thinking, and what sort of amenities should we have? Now, these sorts of questions allow the suspect to freely implicate themselves without inducement.
Is this all that your analysis determined?
No, I also examined it for subtle hints of conversation, subtle hints of criminal activity that would drop during the conversation, such as sweetening the pot and making things happy. Now, these are exactly the sort of subtle hints that should be dropped by our law enforcement officers when they're engaging a suspect in an undercover operation.
Now, I want to talk about Officer Keenan's investigation. What exactly did Officer Keenan do right in her investigation when it comes to linguistics?
Well, I've actually prepared a chart that, in order to show exactly what Officer Keenan did right during her investigation.
May the witness step down to make use of demonstrative evidence?
Any objection to the use of this demonstrative, counsel?
No objection, Your Honor.
Thank you.
Your Honor, permission to move one of the demonstrative?
Absolutely.
You may step down now.
Certainly. Absolutely.
What exactly are we looking at here?
Well, I prepared a bulleted list of everything that I found over the course of my analysis that Officer Keenan did right in the documents that I examined for my analysis.
What about the first bullet point, open-ended questions?
Yes, on March 31st during their conversation, Officer Keenan and Corey Hyde asked classic open-ended questions such as, what are you thinking? Now, these allow the suspect to freely incriminate themselves.
And the second, dropped hints.
Throughout the conversation, both Officer Keenan and Corey Hyde dropped multiple hints of criminal activity without ever expressing what that criminal activity is. Now, this is a classic example of a subtle hint that they could drop, and they allow the suspect to continue to implicate themselves if they latch onto these.
Explain the third one, never mentioned a bribe.
Yes, throughout the entire March 31st conversation, the topic of a bribe was never expressly brought up during that conversation.
And the fourth, repeated the suspect's own words.
Well, upon my review of the affidavits, I did discover that Officer Keenan did bring up money at one point throughout her investigation. Now, normally this is not proper technique. However, in this case, the officer was using the suspect's own words.
And what about the last bullet point, avoided most conversational strategies?
Yes, I also examined both the email exchange and the March 31st conversation for signs of conversational strategies that have been shown through research to induce criminal activity in someone who might otherwise not do it. Or in other words, strategies shown that will make good people do bad things.
Thank you. You may take your seat. Dr. Warren, were you able to come to a conclusion in today's case?
Yes, I was able to come to two conclusions.
What was that first conclusion?
Well, the first conclusion is that when they structured their conversation on March 31st, they completely aligned their conversation within the best practices, as I laid out before you, that have been agreed upon by linguists.
And what is your second conclusion?
Well, that Officer Keenan and Corey Hyde avoided the use of most conversational strategies shown through research to induce criminal activity, and the strategies that were possibly employed were used in a limited scope.
Thank you. At this time, I have no further questions.
Thank you, counsel. Cross-examination?
Yes, Your Honor. Good afternoon, Dr. Warren.
Good afternoon. How are you?
I'm fine. You?
Very good.
Dr. Warren, you mentioned conversational strategies that are shown to induce criminal activity in otherwise unwilling participants.
Yes.
So I believe one of these types of strategies was interrupting the target. Is that correct?
Yes, that is correct.
And I think, well, actually, permission to retrieve what has been previously marked as Defense Exhibit D1 for the witness.
Permission granted.
Thank you, Your Honor.
Thank you.
Doctor?
Actually, I created this document. I reviewed a tape of the conversation, and then I transcribed this document.
Yes, and so, in this, isn't it shown that, I'm sorry, one sec. All right, isn't it shown that interrupting the target has the potential to mass reluctance of the target in order to engage in criminal activity?
Yes, that is the case.
And isn't it true that in this conversation, target, there was in this conversation there was a portion in which Officer Mickey Keenan did, or actually in which Corey Hyde interrupted the defendant?
Yes, actually, line 35, Corey Hyde interrupts Avery Bancroft to say, I think what they want to know is whether you'll do anything to sweeten the pot. Now, yes, this is an interruption of the target. However, he is also providing a subtle hint of that criminal activity here for the defendant to latch onto.
Moving on, isn't it shown that speaking on behalf of the target is also another strategy which has been shown to produce cause criminal activity in subjects otherwise unwilling to commit to it?
Yes.
And isn't it true that in this document, Corey Hyde did interrupt the target at a certain point?
Yes, Corey Hyde interrupted at the instance in line 35 in order to provide that subtle hint of criminal activity, sweetening the pot.
Thank you very much. So now I'd like to move along to the subject of coaching. So isn't it true that coaching of informants or witnesses or informants or other law enforcement surrogates is shown to be another strategy that can induce criminal activity in otherwise unwilling participants?
Yes, coaching of informants is always a potential concern in investigations.
Your Honor, at this time, permission to approach the witness with what has been previously marked as Defense Exhibit 2.
You may, but let's retrieve D1 first and get that.
Very well.
Here you are, sir.
Your Honor, I just asked that I can see this exhibit before.
Oh, yes.
Oh, of course.
Please show the opposing counsel first. So this is a new exhibit.
This is the new exhibit. You recognize this document?
Yes, this appears to be the email exchange that I was provided on March 30th of the email exchange between Officer Keenan and Corey Hyde.
And is this a complete and accurate depiction of that email exchange?
Yes, everything appears to be here.
Okay, at this time I'd like you to read what is the second paragraph in the email from Mickey Keenan.
Yes, you just need to make...
Objection to testifying to evidence that's not entered into evidence. Your Honor, I just asked that they put this into evidence before they began talking about it.
So is there maybe a hearsay objection here?
Yes, objection, Your Honor.
Counsel, are you moving to have this entered into evidence?
Yes, I'm sorry, Your Honor. At this time I would like to enter this document into evidence.
Any objection?
No objections, Your Honor.
It's in evidence.
All right, would you mind reading that second paragraph, please?
Certainly. Second paragraph begins from Officer Keenan. You speaking to Corey Hyde, you just need to make sure that the conversation keeps moving in the right direction. At some point, you might want to suggest that Avery do something to sweeten the pot. It is very important that this comes to you and not me. We can't make it explicit what you'll be asking. You're wearing a wire, after all, but we need to make sure that Avery realizes that to get this done, somebody needs to be made happy, and that person is Chase Covington. Now, this is a classic example of coaching an informant. However, this is coaching of the informant, and the steps that they took...
I'm sorry, thank you. I only asked you to read the document. So isn't it true that you've said that coaching is, in fact, giving the informant specific phrases or words in order to use in a conversation like this one?
Well, yes. However, in this case, it appears that these...
Thank you, I appreciate that.
Coaching...
Objection, Your Honor. I just asked that my witness be allowed to finish his answer.
Don't interrupt the witness.
Well, so as I was saying, yes, coaching is always a concern. In this case, however, it appears that the coaching that was offered in order to structure their conversation in line with those best practices as I laid out before you. So in this case, it is still a concern, but it falls into a slightly more gray area.
So to be clear, those expressions sweeten the pot as well as who needs to be made happy were used directly in the conversation following this email. Is that correct?
Yes, those are classic examples of subtle hints that our law enforcement officers can be using throughout their conversation to allow the suspect to latch onto them and incriminate themselves.
Aren't these also classic examples of coaching?
Yes, they are, which is why it is still some concern. However, as I said, it falls into a gray area.
Thank you. So finally, haven't you said that manipulating the tape, specifically the tape of a recorded conversation, is another strategy that can be used to make it appear as if a target has acquiesced to a crime when they in fact have some reservations?
Yes, that is correct.
And isn't it true that there was a portion on the tape of the March 31st conversation that has some static that is inaudible?
Yes, there's a moment of static during the conversation that it was impossible for me to determine what was said during that point. And upon reviewing those affidavits that I mentioned, there is some discrepancy over what was said during that. However, at the point where I analyzed that static, I was unable to determine whether or not that static was created intentionally or whether or not it was just simply a byproduct of the person who was wearing the wire, in this case Corey Hyde, shifting in their seat.
So to be clear, Corey Hyde was wearing the microphone that had static, that picked up static during this portion of the conversation, right?
Yes.
And we've already talked about that Corey Hyde has, in fact, taken Mickey Keenan's coaching to use during this conversation, right?
Yes, structuring that conversation in line with those best practices.
And he has also interrupted the witness in line with the instructions he received from Mickey Keenan prior to this conversation, right?
Well, he was not instructed to interrupt Mickey Keenan, however,
let
he
me
did interrupt him.
He used the conversational strategies, the specific words that Mickey Keenan had asked him to use, correct?
Yes.
And so at this portion of the conversation, you have said that this portion could be crucial and a crucial point in the conversation. Is that right?
Yes, but I was unable to determine what was said.
And no further questions, Your Honor.
Thank you, counsel. Could I have a copy of whatever was just entered in? Thank you. Any redirect?
Yes, sir. You were questioning a lot about coaching the informant. Now, you said earlier that you teach cadets and law enforcement officers how to construct their conversations. Isn't that right?
Yes, that is true.
So do officers have to tell informants how to construct their conversation?
Well, it is a little bit of pause for some concern, but if there was absolutely no coaching of an informant, that would severely put both the officer at the law and the informant's life at risk. So some level of coaching is probably always going to be put into place. It's just a matter of to what extent that is.
With coaching in today's case, did it follow the best practices that you outlined earlier?
Well, the topics that were brought up were subtle hints, so yes, it does align with what I mentioned earlier.
Thank you. I have no further questions. Permission to approach the witness and retrieve evidence.
You may.
Here you are.
Any recross?